Good morning, everybody. It's a pleasure to see people in person. The last time we were here, it was right before the tsunami hit. So we've got a lot to talk about. We're starting off with a very, very exciting topic, sanctions, everybody. Come on, legal topic. It'll be fun. And since the last conference, which we held virtually, which was February 2022, everything changed. Russia invaded Ukraine, and the rest is history. Sanctions measures were implemented in the ensuing months on almost a daily basis by various authorities, the US, the EU, the UK, the G7, expanding the target list of persons and types of activities by Russian entities, and all in the name of undermining the ability of Russia to wage war in Ukraine. Shipping has had to adjust to these developments in all aspects of the business, from trading commodities to chartering to financing to providing, obtaining, and maintaining insurance and just doing business. And this is going to be the focus of our panel, emphasizing the use of sanctions by all these various international organizations and authorities, and see how it has challenged the shipping industry in the past year. But before we do that, I am a history buff and I am a movie buff, so I'm going to combine the two. I'm going to channel my Gus Portocalis, Big Fat Greek Wedding, and say, you know, the Greeks, they invented sanctions. And it's true. I mean, I'm just not making that up. Back in 433 BC, and we're not talking about some obscure moment of Greek history. We're talking ancient Athens, Pericles, the height of, the birthplace of democracy. Pericles issued what was called the Megarian Decree in 433 BC. This was the first peacetime use of economic sanctions against a targeted political entity, and at that time they targeted the Megarians, who had apparently used Athenian lands without authority. Sounds like an episode of Yellowstone to me, but that's another story. Anyway, Pericles banned them from all the ports within the Athenian Empire and from the Athenian market. Athens thought that it would not prompt a war. At the time, Athens and Sparta were, of course, competing for power and influence in the Balkans and the Mediterranean. But Sparta came to the aid of its Megarian allies and threatened Athens to withdraw these sanctions, which Pericles and the Athenians, of course, said, well, we can't withdraw them. You can't force us to withdraw them. If we do, we don't have any freedom. It would be like slavery. So at the end of the day, they refused, and it prompted the Peloponnesian War. And within 30 years, of course, Athens lost that war and democracy disappeared in ancient Greece. So Pericles, Athens, sanctions, there you go. Hopefully, our discussion is going to be a little bit more positive than what happened to Athens. We have with us a very prominent set of sanctions specialists and lawyers, unfortunately we're all lawyers, with a lot of sanctions experience here. So without further ado, I'll introduce them. We have Dan Tadros, who's the Chief Operating Officer of SCB, the manager of the American Club. Nik Ivanov, Vice President, Head of FD&D of Skuld, New York. Bruce Paulsen, partner at Seward and Kissel here in New York. And Matt Thomas, a partner at Blank Rome in Washington, D.C. And Louis Epstein, General Counsel of Trammo, Inc. And with that, why don't we just dive in and start off with the state of the current state of affairs regarding sanctions in the U.S. in the aftermath of the invasion of Ukraine. So, Bruce, why don't we start off with you? Could you please do your best to try and summarize for us what sanctions measures were implemented by the U.S. and perhaps identify what sectors of the economy, of the Russian economy were targeted, and perhaps what commodities?
Thank you, George. I guess the equivalent of the Megarian Decree in February and March 2022 actually a series of decrees. The sanctions came in waves, and all of us in the sanctions space know there are basically three types of sanctions: primary, secondary, and sectoral. Primary sanctions, think Iran, think Cuba. U.S. persons can't do business with people in those countries. Secondary sanctions, U.S. Legislating extraterritorially against foreign companies and nationals. And then sectoral sanctions aimed at certain business sectors or other sectors of an economy. There is a primary sanctions piece to what happened in 2022. In 2014, we did have Crimea as a territory-wide embargo. Added to that were Donetsk and Luhansk in eastern Ukraine in March of 2022. You have 4 directives aimed at 3 sectors of the Russian economy: the finance sector, primarily, that's what most of these are about, the energy sector, the defense sector. Banks were subject to full blocking sanctions: Alpha Bank, Spur Bank, you name it. Major players in the shipping space, Sovcomflot, subject to directives preventing any kind of new debt or equity issuance. You can't extend credit to entities in the Russian Federation. Extending credit, and there's something that everybody does without even knowing it. You have bills that overdue. Have you extended credit? There's a lot of risk out there in that space. There were sanctions against the central bank. There was the U.S. oil import ban. There have been numerous and ongoing designations of individuals and entities as specially designated nationals or blocked persons, SDNs. That is probably the single biggest part. The rollout of SDNs, many of the companies that everyone in this room did business with, as well as many Russian oligarchs. A lot of the work that we were doing for our investment management clients in the spring of 2022 was, what do you do when you have an oligarch who invests in your fund? What do you do if the investment managers in the United States, the fund is in Cayman, and you have a Russian oligarch investing through a nominee or a sibling or a spouse, that sort of thing? These were complicated questions. You had prohibitions against correspondent accounts. You can't provide something like accounting services to entities in the Russian Federation. So if you are any kind of operating company or a financial institution, you're providing a statement to someone in Russia, you may be inadvertently providing accounting services to Russia in violation of sanctions. There are no investments in the energy sector, no luxury goods. KYC, boy, is that the order of the day at this point. I recommend to all of you to look at the 2019 guidance by OFAC for compliance. It lays it out in fairly simple terms, but you need to know who you're doing business with, you need to have internal controls, and you need to have a compliance program in place that'll help you if you ever get into trouble with this. So, and then recently we'll get more into, with Matt, into the oil price cap, which was instituted just in the past few months, and part of it went into effect this past Sunday. So that's the big recent news. The EU and the UK also rolled out sanctions programs during this time. Some of those were a bit like what OFAC does. Some of them are a bit different. For instance, a U.S. person can't do business with an SDN or a company owned in the aggregate 50% or more by SDNs. In the EU regime, it's ownership or control. Very simple to find out if somebody owns 50% or more of a company. Control, deeply factual question. That makes your compliance harder. A lot of self-sanctioning happened. Players got out of the market at the outset of the war in Ukraine and did so voluntarily to stay out of trouble. That continues to this day. There were businesses that you had to get out of. There were wind-down periods. Most of those are past. In any event, it was head-spinning, and now we live in the aftermath.
Thank you for that, Bruce. And that essentially takes us up to the period when the price cap was getting implemented. And we'll look to Matt now to set the stage, give us a bit of the background that prompted it, and then explain to us what the price cap actually is.
Sure, thanks. And that was a great recap, Bruce. The price cap, there's a number of kind of themes and takeaways from this. Like we've talked about here for year after year, shipping and energy just continues to be a central focus more and more of foreign policy initiatives and sanctions to imply pressure on Russia, Iran, Venezuela. But how the price cap was imposed in this case, though, was very different, much more surgical and much more multilateral than we saw with the sort of what now looks like sort of blunt instruments with Iran and Venezuela. The price cap was an initiative by the G7 plus Australia to collectively ban the export of Russian crude oil and products, but with an or ban the provision of services, trade finance services, shipping-related services, customs brokerage, for that trade, but with a broad exception for any cargoes that were moving under the price cap that was announced, and the objective of this was not to chop off trade like we saw with Iran or Venezuela. There was a number of more sort of nuanced objectives. Secretary Yellen talked about the need to maintain stability in the energy markets and insulate developing economies from the price shocks that came as a result of the Russian invasion. There was a talk about the need to maintain this pricing stability without basically upending oil markets. So we've seen this in December 5th, the implementation of a $60 price cap for crude oil, and it has gone relatively smoothly because of relative administrative simplicity and a relatively high level of the price cap, and part of this has really been due to the level, sort of a maturation of the dialogue between OFAC and our industry, the shipping industry, energy and charterers and things. A lot of feedback went into OFAC as the policies were, and the State Department, as these policies were being developed. And this dialogue was continued in the G7 group between and among the US, the EU, and the UK. So one big result of that dialogue was that we developed this system based on attestation. I mean, I don't want to say this is the honor system, but instead of requiring every actor in the energy supply chain to do due diligence, look at documents, verify that oil is trading under the price cap, we have a system where ship owners and P&I clubs can get assurances, can get written certifications or attestations from charterers that the oil is trading under this price cap. OFAC really onboarded input from us that the ship-owning sector just doesn't have access to granular pricing information, and the system really would grind to a halt if we had to try and extract that from all of the charters and counterparties. There was a ton of interesting issues that sort of came up in the development of these policies, including when the price cap applies. You would think right at the outset, well, the price cap should apply to the Russian seller, to the Russian producer putting this on the market. That's where you're trying to sort of cut that off. But in fact, the price cap applies through the whole ocean voyage, and even if it goes into storage someplace and the oil comes out and is shipped on the water, price cap continues to apply. There's some interesting policy reasons for that.
Matt, if I can just
just one last sentence. And in the last few days, we have seen we've seen the rollout of the price cap for products, which again is done in a fairly simple way, with a price cap for products going under pricing at a discount to crude, and one price cap for things like diesel trading at a premium to crude. And so this again seems to be working just in very early days.
Thank you, Matt. You mentioned P&I clubs, and of course we have two panelists that are from two IG P&I clubs, one US based, one non-US based. And I wanted to start off with Dan. Dan, given everything we've heard and considering the attestation process and the price cap regime in general, can you share with us some of the experiences you had with the club's membership and how you've seen this in practice?
Sure. Thank you, George, and good morning, everybody. It's good to be here among this distinguished panel. A couple of things that I wanted to mention. First of all, Bruce talked about secondary sanctions, which really are the granddaddy. That's when you really go after a country, okay? That's what happened when the U.S. went after Iran. That hasn't happened with Russia. And you're going to understand why I'm bringing this up when we start talking about how our sanctions working a little later. As far as the P&I clubs are concerned, we, and I'm going to speak for us because we're based here in the United States, okay? We've been dealing with sanctions for years. Way back when George was still at the club, we were dealing with sanctions, something that a lot of our brethren clubs maybe didn't have to deal with as much as we did because we were in OFAC's backyard. So what happened now with the Russian sanctions? Well, we all know how OFAC reacts. When they set out rules and they want to go after somebody, they're going to designate you, okay? Well, with regard to the oil cap, and especially with Russia, guess who took back seat? The United States. OFAC took a back seat, allowed Europe and the UK to forge ahead with sanctions. So what was the result? Some very complex, confusing, and often very contradictory provisions coming out of the EU especially. Not so much the UK, because the UK follows pretty much what OFAC will do. So what did that mean for us, the P&I clubs? We were in a vacuum. We were getting calls from members wanting to know, is there a cargo that's permissible? Is where I'm domiciled an issue? If I go through Europe, do I have a problem? What if I bunker through Europe? Can I take this cargo to the Far East? Can I take it to a European country? Every day, the nature of the inquiries was overwhelming coming in, okay? And it never became simpler. And I want to give you an example of that in, I want to say it was late August, maybe early September. The press wrote about and I'm going to just say a Greek owner whose company is what we call in Greece Law 89, which is not a Greek company, it's a foreign company doing business in Greece, okay? And the big headline was this huge Greek owner was illegally transporting coal. And at the time, Europe had just come out with the restrictions on coal and fertilizers. Well, that wasn't true, because if you really look into it and you look at the regulations, a foreign company doing business in Greece is not a Greek company. It means it's not European. The vessel of the flag was non-European, and it was carrying the coal to India or China, somewhere that had nothing to do with Europe. So, in effect, that trade was not illegal, okay? That's how confusing all these regulations were in the beginning. Now, Europe has heard from the industry and came back and made it clear now what applies to fertilizers and coal. Bottom line is that the sanctions are still confusing, and they create havoc among owners and the P&I clubs.
So is it fair to say that the answer to all those questions was, it depends?
It depends.
Okay, well, let's go over to Nik. Nik, Skuld had a sizable membership in Russia before hostilities broke out in Ukraine. Tell us about what your club went through once the sanctions were implemented against Russian shipping companies and other targets.
Yeah, thanks, George. Firstly, I should say, although there are a few Nik Ivanovs on the SDN list, I'm grateful that I'm not one of them. At least not yet. Anyway, just to echo what George said, Skuld has traditionally had a very strong Russian membership. That put us in a very unique position insofar as having to do a very strict internal review of our membership portfolio and make some very difficult decisions. Well, actually, the decisions themselves weren't particularly difficult. We knew what we had to do, but it meant that we had to part company with a large number of valued and historically very embedded members. So that was difficult. I can't obviously talk about specifics, but what I can say is that we concentrate often when we think about sanctions on the compliance of our membership, but we also have to remember that the insurers have a very strict obligation to comply with sanctions also. And that puts us in a very difficult bind because we're in between the sanctions authorities and the practical part of the shipping industry, the charterers and the shippers. And so we act as a buffer between the two, and we have to effectively police up and down the sanctions chain, as it were. So it's been a challenging time, but when I think that we and the IG group of P&I clubs in general, I think, have navigated very well.
Thanks for that, Nick. And a follow-up question for you. Skuld has a sizable charters membership as well. I mean, have you, in terms of the attestation process and the different tiers that have been established in the price cap regime, can you share with us any, just describe for us some of the challenges that you've experienced as a P&I insurer?
Right, yeah, well, kind of echoing what Dan said, one of the biggest challenges we've faced as a P&I club, and I think this is a challenge faced by all the IG P&I clubs, is that the sanctions regimes and the price cap scheme that's been rolled out has been rather short on implementation and guidelines, at least until the last minute. And so it's been left to the P&I clubs and the other insurers to effectively overcome the implementational challenges that the sanctions provide to the owners and charterers. I've got two illustrations of that. Firstly, with respect to the emergency carve-outs. So when the sanctions policies were first introduced, or at least mentioned by the authorities, there was no carve-out envisaged for large maritime emergencies. And the IG liaised with the sanctions authorities in the UK, the European Union and the US to negotiate with and in fact implement a carve-out to allow ships to trade, and if there is a maritime emergency, for not being hamstrung by sanctions issues in circumstances where there may be cause to the CLC or the Bunker Convention or the Wreck Removal Convention, so that third-party claims can be protected and P&I clubs can work unfettered. So that was, I think, a good example of how the IG worked very hard to overcome the challenges that the sanctions regime brought up. The second one concerns the attestation process, which you've mentioned. Now, if a P&I club has reasonable suspicion that one of the cargoes carried by its members does not comply with the sanctions rate, with the oil price cap regime, then they are obliged to withdraw cover. So that means that there is a level of trust involved in terms of what's declared with the cargoes. But there's also documentary requirements. How that is designated is determined by what's called a tier regime. So there are 3 tiers. You may have heard about this already, but let me just very briefly recap. So basically, a maritime service provider is designated by one of 3 tiers. Tier 1 is the closest proximity to the price cap information or the price of the cargo. Tier 2 is the intermediate tier, and Tier 3, which is usually where owners or P&I clubs would be designated, have very little direct information concerning what the actual unit price of the cargo is. And that is a real challenge, because on the one hand, you have that tier designation. On the other hand, we have no practical information, and we have been asked as a P&I club to effectively police the price cap compliance. So there's no public registry for this price information, so there needs to be some form of protection to a P&I club who receives an attestation and isn't able to verify the price cap. And the approach is taken by the US is one of what's called safe harbor. There's a assessment of good faith, and if you've got if you've exercised good faith and complied with your documentary requirements, then you're given a level of protection by OFAC. No such protection exists in the EU implementation of this policy. There's no safe harbor requirement, and in fact, they require due diligence. What due diligence means is really anyone's guess. We as lawyers know that due diligence is something which is, it's a movable feast sometimes, and so it puts a great deal of uncertainty on how the attestation process is going to be administered in the long run.
Thank you for that, Nick. In fact, you were talking about safe harbor. OFAC has made it crystal clear, and this also ties in with Dan's comment about secondary sanctions, at least down the road. OFAC intends to focus its enforcement responses on those actors who willfully violate or evade the price cap. That's something that was expressly stated in the last guidance that was issued. So we have to bear that in mind. We'll come back to that, or if you want to add something to that, Dan.
Yeah, if you don't mind, George, I wanted to add something just to illustrate the lack of understanding by the governments of the shipping world. I'm part of the IG Sanctions Committee, so I traveled to Washington to meet with OFAC and to meet with the State Department, okay? And when we first got there, the original version of this oil cap, the price cap, included the word shipper, because to the U.S. government, shipper meant the ship, the charter, the supplier, anyone who gets the oil. Well, that's not how it works. So we sat there for 2 days explaining to them, and they finally understood there's a big difference between a ship owner who's just going to carry oil. He has no idea how much that oil was sold for. That only is the actual shipper, seller of the cargo. And that's why OFAC came out with a distinction and this safe harbor because of the IG. And I agree with Nick. The IG worked very hard, both meeting with the U.S. governments and the governments in the EU and the UK to ensure that they understood how the shipping market works.
Thank you for that, Dan. Well, I would like to turn the floor over to Louis, because Louis has the distinction of being every one of those things that you were talking about, Dan. So he gets to be every tier on the scale. And with that, I'd like to just ask Louis just to give us a description of their experience the last year in every sense, from supply chain to compliance to their experiences with the sanctions in the aftermath of the invasion.
Thanks, George. As some of you may know, Trammo is an international commodity trading company with its headquarters in New York and offices around the world. Among other things, we're the world's leading traders of anhydrous ammonia and sulfur, products that are mainly used in the production of fertilizer. Over many years, Russia and Ukraine have been major sources of supply of ammonia, sulfur, and other fertilizer products. In addition, because of Soviet-era logistics networks, ammonia and sulfur produced in other former Soviet Union countries have typically been shipped through Russian and Ukrainian ports. The war and the sanctions that have been imposed since its outbreak have had a significant impact on the supply of products originating in and passing through Russia and Ukraine. First, most of the ammonia produced in Russia and Ukraine was transported via the world's longest ammonia pipeline, about 2,500 kilometers, from the Tolyatti Azot plant in Russia, the world's largest ammonia plant, to an ammonia terminal at Yuzhny near Odessa in Ukraine, where it was loaded on ocean-going vessels for export throughout the world. Since the war, no ammonia has been transported through the pipeline. In connection with the grain deal in effect between Russia and Ukraine, there have been negotiations involving the United Nations about reopening the Tolyatti pipeline. As reported in the press, Trammo has been approached as a possible off-taker of the ammonia, but thus far no agreement has been reached between the two countries. Second, some of the major Russian plants producing ammonia and other fertilizer products are or were in the very recent past owned by Russian oligarchs who have been named to the U.S. SDN list or who are on lists of sanctioned persons promulgated by the EU, the UK, and other countries. Generally speaking, if a person is on such a list, transactions with a company owned or controlled by that person or involving its property are prohibited. But as Dan has pointed out, there are significant differences among the various lists and in the approach of different sanctions authorities to enforcement. These differences have created challenges for companies whose operations touch upon multiple jurisdictions. As an example, let's take a company called Eurochem, which is a major Russian fertilizer producer and markets its fertilizer through a Swiss company. Eurochem, the company, is not on the SDN list, the US SDN list, and it's not on the EU list of blocked persons. But on March 9th, 2022, the person who had been the majority shareholder of Eurochem, Andrei Melnichenko, was named to the EU sanctions lists. Before sanctions were imposed on him, Mr. Melnichenko divested his shares in Eurochem to an offshore trust of which he was the main beneficiary. Shortly thereafter, his wife replaced him as the principal beneficiary of the trust. When news of this was published, the EU added his wife to the sanctions list. The result is that in Europe, many transactions with Eurochem have effectively been prevented by concern that it is owned or controlled by a sanctioned person, either Melnichenko or his wife. And Dan mentioned I think it was Dan, or no, Bruce mentioned the difference between the criteria employed by OFAC and by EU authorities to determine ownership or control. In contrast, in the US, although Melnichenko was named to the SDN list in August 2022, on the same day, OFAC issued guidance stating that Eurochem Group AG is not owned 50% or more by blocked persons or otherwise considered the blocked property of Andrei Melnichenko. So although US sanctions law clearly does not prohibit transactions with Eurochem, EU sanctions against Mr. Melnichenko and his wife may still effectively prevent such transactions for entities subject to EU jurisdiction. And also, when I say that the EU is still enforcing sanctions against Eurochem, the extent to which it is doing so may vary from member state to member state. That is because while sanctions are imposed on the EU level by a decision of the EU Council, interpretation and implementation of sanctions is vested with the EU's member states. And it's up to each individual member state to decide whether it will treat an organization allegedly associated with a sanctioned person as also being sanctioned. This is in contrast to the United States, where one government entity, OFAC, is in charge of enforcing sanctions and does so in a fairly uniform fashion.
So it would be fair to say that it's difficult to navigate between compliance with US regulations and EU regulations.
That's right. It's challenging. And I think a factor of importance in Trammo's business is the universal desire expressed in policy statements issued by the EU and United Nations and the US, among others, that sanctions should not contribute to food insecurity. But again, there's a big difference in how the various jurisdictions implement that policy. And I think one last thing I'll say, I know our time is fleeting, the existence of independent and inconsistent sanctions regimes has also had an effect on compliance. Historically, the U.S. was the most aggressive jurisdiction in imposing and enforcing economic sanctions. And if you were complying with U.S. sanctions, you didn't really have to worry too much about whether you were going to comply with the much less stringent EU sanctions. But that has now changed, and we really have to pay close attention. And finally, this was alluded to also by Bruce and Dan, I think there's a phenomenon of self-sanctioning where in less banks and insurers and other participants in international trade really want to get deep into the weeds. They are reluctant to get anywhere near transactions involving products flowing through Russian ports, for example. So that's more or less the big picture for Trammo.
Thank you, Louis. Well, I know we're running out of time, but just everyone starting with Matt and coming down the line, are these sanctions working?
Yes, they're having an effect. I think in terms of themes and trends for the next year, there's really going to be more of a focus on catching cheating. We're seeing an escalation in the sophistication of evasion efforts, and especially the situation off Malaysia and the growth of the dark fleet and things. We've got quality shipping and quality charterers and majorers saying to governments, and we're making the point to governments, look, this is disrupting markets, having this bifurcation into quality and dark regions of shipping and trading. And it's something I think over the next year or two you're going to see more enforcement activity and focus on the real cheating.
Okay, unfortunately, it's got to be yes or no, guys. Dan, what do you think?
Yes, I think they're working, George,
Okay. Thank you.
especially from the moral standpoint.
Bruce?
Well, they probably started working before they even went into effect by way of self-sanctioning, but the oil is still flowing.
Right.
And the war is still going on.
Yes, it is. Nick, thoughts?
Can I say I don't disagree. I think they are working, but there are areas of concern. Very, very quickly. Matt talked about quality shipping. The problem is the growth of the dark fleet. That's not quality shipping. That is ships that have been transferred ownership. They are now insured by questionable internal Russian insurers. Who knows what's going to happen if there's a major maritime casualty and how that's going to be served and how the wider shipping environment is going to be protected. So that's a concern, and against that, Russian trade volumes haven't really decreased that much.
Right.
So in those circumstances, I think the jury's still out.
That's a maybe. And Louis?
I think, yes, they are working in terms of making people very wary of doing any business touching upon Russia. They're not necessarily, people are not necessarily fully aware of the nuances and of the differing policies underlying the sanctions and matters such as.
And that's why you should reach out to everybody on this panel to get some guidance. I want to thank everybody for participating. We're going to open up the floor to questions now. Before you ask a question, please look for the microphone so that way everyone can hear the question being asked.
Hi, just to confirm, Nick and Dan, just to confirm, your clubs, have they provided cover for any tankers that have carried Russian oil under the cap so far? And if so, is that something that you would like to do more of as you become more comfortable?
Do you want to start, Dan?
The answer is yes.
Not that I'm aware of from my side.
I think that's going to have to be the last word. We're running a little bit behind schedule, but I'd like to thank all of our panelists for their participation, and we'd like to thank the both chambers for allowing us this opportunity to present to you. Thank you very much.